Personal injury action, lawsuits, we hear about them all the time. We hear about juries voting in favor of money being paid to a plaintiff. But what happens when the plaintiff, the person bringing the action, loses? Takes us to this week's case. Involves a real man. First name Randall. Randall, student, Cornell University. He was involved in a gymnastics activity at the university and suffered a significant injury, a horrible injury. He wound up paralyzed from the neck down. Brought suit, sued Cornell University. Case went forward, was tried in federal court, and at the end of the case, it was found that Cornell was not at fault, and Randall lost the case. Well, after the case, Cornell University brought claim under what's referred to as a cost bill for the amount that they had to spend just in cost, expenses that they had in order to defend against the case brought by Randall. They said that these costs were roughly $100,000. In opposition, Randall, through his lawyers, argued, well, they didn't need some of the transcripts, they didn't need some of the other things, and in short, that, gee whiz, while there were some costs, some expenses that they had, they weren't $100,000. They really should have been less than that. When this was heard by the U.S. magistrate, who heard the motion, the U.S. magistrate said, hey, I disagree. I disagree. In this instance, I find that Cornell, in fact, was entitled to recover not only $100,000, but they were also entitled to recover an additional $25,000. In short, that they were entitled to recover approximately $125,000 in various costs and expenses. Now, that's not attorney's fees and just costs and expenses as a result of having to defend against the case brought by Randall. As a result, Randall is now looking at judgment against him for $125,000. That will probably force him into bankruptcy. So what's the lesson we learn from this? What is the lesson we learn from this? A very simple lesson. We always hear about large awards being granted in favor of plaintiffs. But when things don't go well, a plaintiff can be responsible for the costs incurred by the other side, the expenses incurred by the other side, if they, in fact, don't win the case. In this instance, we see $125,000 in costs. So when people hear about frivolous lawsuits, people will not bring lawsuits when, in fact, there's a possibility that they could get hit with some very significant judgments for just costs. And so when you hear about frivolous lawsuits, well, it doesn't happen. It doesn't happen because people will not put themselves at jeopardy if indeed they can avoid it. And most people want to avoid that. Bringing a lawsuit is something you need to think long and hard about in many instances. Okay, we bring you this case as we bring you cases every week so you understand how the law works. I'm David Allen.